In July 2024, Defendant Daryl Jarrell was charged in the 14A District Court of Ann Arbor, Michigan, with 2 misdemeanor counts of trespassing. The charges were not felonies and therefore did not require a preliminary examination. Mr. Jarrell was arraigned on July 24th, 2024, and the court scheduled a pre-trial conference for August 7th, 2024, before Judge Cedric Simpson. Assistant Public Defender Lauren Perry was appointed to represent him prior to the scheduled pre-trial. Defense counsel had been unable to communicate with Mr. Jarrell due to his lack of a telephone, email address, or reliable means of contact. Mr. Jarrell indicated he had no phone and limited access to a post office box. The court sought to ensure meaningful communication between attorney and client before further proceedings. Consistent with Michigan court practice and the defendant's Sixth Amendment right to effective assistance of counsel, Judge Simpson proposed adjourning the matter to September 4th, 2024, allowing additional time for correspondence and case preparation. During the scheduling discussion, however, the defendant became frustrated with the delay. His reaction to court's attempt to extend time for consultation initiated a conflict that ultimately shifted the case's focus away from the trespassing allegations and toward issues of courtroom conduct and contempt.
Miss Perry is so happy to see you.
I am very happy to see you. Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Jarrell. Please state your name.
Hello, Gerald.
Okay. And where are we on his case?
Your Honor, we have not had contact prior to today. I think the number we have for you may not.
I don't have a phone. So whoever gave you a number, it was invalid.
Okay. So I'll need to figure out a way to get in touch with him so we can go over the case together.
So are there 2 separate?
If I give you my number,
What is?
you have a PO box?
I don't have a phone. I have Blonde Center. Use a PO box, I think.
Okay. Do you have an email address?
No. I'm on the radar. Use electronics.
All right. So you guys are going to be trying to figure out a way to get to make contact with each other, right? So.
Yeah.
Okay. So
At the August 7th pretrial conference, the court addressed procedural matters, including defense counsel's inability to contact the defendant. Judge Simpson explained that additional time was necessary to protect Mr. Jarrell's right to consult with counsel, noting that a pretrial conference serves as a case management hearing to address discovery, motions, and scheduling. The court therefore proposed resetting the matter approximately 1 month later. Mr. Jarrell questioned the necessity of delay, stating that the case involved only trespassing charges and expressing a desire to leave the state. He suggested he could simply depart and allow a warrant to issue. His tone escalated into open defiance and profanity directed at the court. Judge Simpson warned that such behavior constituted contempt. Despite repeated warnings, the defendant continued the outburst. Because the conduct occurred in the immediate presence of the court, Judge Simpson exercised a statutory authority under Michigan compiled laws sections 600.1701 and 600.1711 to punish contempt summarily. Finding multiple separate acts of insolent and disruptive behavior, the judge imposed a maximum penalty of 93 days for each instance. 6 separate findings resulted in a total sentence of 558 days incarceration. The initial hearing, therefore, concluded with immediate incarceration based solely on courtroom misconduct rather than the underlying misdemeanor charges.
Well, the reason I say that is let me just do this. Let me give you a little bit of time so that I'm going to adjourn this out to September 4th, 2024, 9 a.m.
What's the holdup?
Oh.
It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th.
Mhm.
They set this date. Your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to I can set it for 2 weeks out,
Yeah.
but the problem,
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
you know what?
It's a
You know, no,
well-constructed-
no. I'm gonna tell you what. You don't come
Then
in
fuck
here, you don't.
Fuck you.
Okay, that's contempt. That's 93. Keep going.
Fuck you.
That's another
Fuck you
93.
again.
That's another 93.
Fucking game.
That's another 93. That's another 93. That's 693s consecutive. Case People versus Keith Jenkins.
Following reconsideration, Judge Simpson reduced the contempt sanction. Instead of the previously imposed 558 days, the court imposed a single 93-day term, representing the statutory maximum for one contempt finding. Mr. Jarrell received credit for 6 days already served. The remaining 87 days were suspended, meaning the defendant would not serve that portion unless he engaged in further contemptuous behavior. The suspension was expressly conditioned upon appropriate conduct at future proceedings. The pretrial conference remained scheduled for September 4th, 2024. However, Mr. Jarrell failed to appear on that date and again failed to appear on October 18th, 2024. As a result, the court issued a bench warrant. He did not return to court until October 14th, 2025, when he was apprehended on that warrant. Ultimately, both underlying trespassing charges were dismissed in December 2025. The case therefore concluded without conviction on the original offenses. Nonetheless, the proceedings demonstrated the court's authority to impose immediate sanctions for contemptuous behavior and the substantial loss of liberty that can arise from courtroom misconduct, independent of the merits of the underlying criminal allegations.